Hello, my name is Krishnan. Welcome once again to my presentation episode number 8 of Inheritance Law. In my previous presentation, I covered legal heir certificate that was very simple and easy to understand. Now I will take you to the second instrument, that is succession certificate. This is an alternative to will, and in case you have not made the will, this will be required to transfer the immovable property. So today we will learn about this and also see a comparison between legal heir certificate and succession certificate. In the subsequent videos, I will cover gift, release deed, etc., and finally comparing it with will. So once we cover all this, you would have completed all the inheritance instruments and would have been in a better position to know about all, that is will, succession certificate, legal heir certificate, etc., and you can apply suitably as per your requirement. Now let us look at the topics that we are going to cover today. Succession law, process of getting succession law, and comparative chart between succession law and succession certificate and legal heir. Now let us go to the next topic. Succession certificate. Succession certificate provides you another method for smooth transition of your hard-earned wealth to your chosen successor after your death. Legal heir certifies the relationship and direct heirship. Succession certificate authorizes one or more persons to transact or operate the deceased person's assets. Succession certificate is needed to inherit any debt and securities, to deal with them, to regulate, administer the assets, and also protect persons who are dealing with the representative of the deceased persons post his death. That is, if you have a succession certificate, you can inherit and you can operate, you can transact, you can do all these things. Like in a business, if there are business things, business of transactions, that all you can do, because at some point of time those other business people, they must be transacting with somebody in the system after the person's death. Therefore they will need somebody who is authorized. So the succession certificate authorizes that person to transact on their behalf, right? But legal heir certificate will only give you the legal relationship. It doesn't even allow you to inherit. Forget ownership. There are two parts. One is inherit, then ownership. Succession certificate allows you to inherit and do the operations, transactions, etc. Legal heir certificate only establishes relationship, does not even allow you to inherit, and both does not allow you to own up. There is no ownership under both. Legal heir certificates can be used for transfer of entitlements and benefits, example bank interest, or you can use it for any financial transactions like demat, provident fund, pension, or some FDs. So those things you can do. You can take it and change it, etc. It also allows you to transfer the vehicle. That's another point. While succession certificate is required to acquire the debts and securities which are movable assets. Now succession certificate, you are entitled to acquire, inherit, and once you acquire, inherit, then you operate that. Without inheriting, you cannot operate. Legal heir certificate does not allow you to inherit. Succession certificate allows you to inherit or acquire them, but not own them, and then you can operate. Court normally would issue a succession certificate to only a legal heir, but often people who are illiterate or women or children who do not know what this is all about, they seek help, and court can also allow an outsider to be a succession certificate holder. So it is prudent first to get legal heir certificate, transfer whatever is possible. So that's what you should do. Apply for a legal heir certificate. That takes about 40-45 days, 30 to 45 days. Get the certificate, transfer all these financial instruments. Then with the help of that, you also apply for a succession certificate. Then succession certificate is easier to get it. It can be taken everybody's name, or you can nominate one person who will be a succession certificate holder. Okay. Now both this, it is only allowing you to operate or do anything on movable assets, nothing on immovable assets. However, when you have a succession certificate, you are allowed to sell a immovable property, not own it. Clear? Now let's go to the next section. After succession certificate, can be, as I mentioned, succession certificate can be only be given when there is no will. It can be used for transferring debtors and creditors, that is take charge. Once you get this certificate, you can stake claim over any movable asset, inherit it but not own it. So you can inherit but not acquire it, not own it. This also establishes authenticity of the heirs. Since this is coming from court, it gives you the authority to inherit debts also. Since the court certifies, it becomes legal. While legal heirs establishes the relationship and thus allows you to link yourself to the assets as rightful receivers, but not inherit or own. Legal heir does not have both. Succession certificate establishes the authenticity and allows you to administer. It is like giving authority or to the person to represent the deceased, or you can say he is acting as a trustee. But then what happens if you want to own it up? If you want to own, so you have a succession certificate that allows you to operate, but you want to own. Let's say you have a house, you want to own it up, your father's house. So what do? You will need an additional document called letter of administration. You need to apply for that, also attaching same set of documents as required for succession certificate. But ideally first you must get succession certificate so as to start administering and getting money due. And also because letter of administration is issued stating you are an authorized person to administer succession certificate, it takes a longer time. While a legal heir certificate you can get within 35, 40, 45 days, a succession certificate would go anywhere between few months, let's 6-7 months. And if you are applying for a letter of administration, it can take even 1.5 to 2 years. Okay, so usually say succession certificate with, now I am talking with administration of with the letter of administration is secondary to will being primary, but both have equal rights. Okay, but if there is a will, succession certificate will have no value, it is redundant. So what is the use of succession certificate? Basically you can stake claim on assets, realize debts, securities like bank, FDs, etc., and operate on behalf of the owner. So that is on succession certificate. Now let us go to the next topic, which is how to obtain succession certificate. Okay, you need to apply to the concerned district judge with all documents or the High Court. The department will verify the documents, and after preliminary hearing, and if they are satisfied, every document is in place and they are satisfied, then they will issue a public notice which will be kept open for 45 days for any person to take any objection. And if no objection is received, then they will issue the certificate again after giving a final hearing. Where there are multiple beneficiaries, the certificate will be issued with all their names. Otherwise, all of you agree, all the legal should agree for one person. And when they agree for one person, it is always better to be safe to have a fair and family agreement, because one doesn't know how things turn after one gets the properties and all. We have seen many cases. We have seen Gautam Singhania and his father, who was ousted. Once he gifted to him, he was ousted, no? So he is now staying. He was staying on the road, but now some people have given something, and he has got a house. He is to stay now, small house. So anyway, Vijay Singhania. So if your court can issue succession certificate in multiple names also, but then while operating it will be very difficult thing to operate. So ideally it should be given to one person. Other should give him the release order, him or her the release order, and all should also get into a family agreement for any future issues. right? So the second part continuing. Okay. They will issue only one certificate, and it will have multiple names if required. Often they ask petitioner to give bond with surety of similar amount. Now what is this? So today the court gives you a succession certificate. Now 10 years later somebody comes and makes a claim, and this claim seems to be genuine. Where how does the court hold you? So they will ask for a surety. They'll ask you all to give all bonds and affidavits, then they'll ask you for a surety also of the same amount. Suppose you have asking for succession certificate for monitoring or taking over assets worth 5 crores, then you need to have a surety also for the similar amount. However, this does not necessarily mean that certificate holder is the owner of the securities or under succession certificate. Only when he gets a letter of authority, that time after you give the surety, it is equivalent to the authorized owner. The legal years are determined by, as I told you, by the legal year certificate. One suggestion is that you should all cover all the assets at one go. The reason is you should not be spending twice on advocate fees and the court fees, etc. Now let us go to the comparison. There is a small last item which is a gift deed, which is also an alternative. I'll be having one full slide on this. Therefore, we shall discuss this in much more detail later on. Gift deed is an alternative, but little costlier. We'll see it in the later slide. Okay. Yeah, I think the comparison is very clear. It is nothing but collated from the statement made to differentiate between succession certificate and legal heir. We shall see a bigger comparison of will, succession certificate, legal heir, gift, release deed, etc. at a later time. As you already know, one is issued by the Tehsildal's office, that is legal heir certificate, and the authority for succession certificate is the court. While legal heir would take 30-45 days, as I mentioned, the succession certificate would take few months, 4, 5 or 6 months. Okay. Succession certificate is more authentic since it is issued by the court under its seal and goes through a set of checklists and verification before issuing the succession certificate. That is why many institutes call for a succession certificate, and only those where one gets benefit allow legal heir certificate. If you want to take control of debtors and creditors, ideally you should have succession certificate, not legal. Contents all relationship of the applicant to the disease is established. Here it only says who are the legal heirs under legal heir certificate. Functions: establishes the authority of certificate holder to inherit debts and securities of the deceased. Legal heir not applicable because the only function it does is to establish the relationship. That is only function. Here in case of succession certificate, it establishes the person who can inherit debts and securities and can also transact and operate the business. Effect: finally both do not have ownership, but at least in succession certificate you can inherit. That's only effect. Friends, we have today covered the second alternative, that is succession certificate. The purpose of this and the previous video, that is legal heir, you have understood, and both are secondary to will. In the next series we will take up a major subject of nomination, and along with it shall also discuss how it is treated under cooperative society and DMAT and other places. If you like my video, please do not forget to click on the subscribe button and also leave your comment. Please pass on this videos to your other friends, so let them be educated and let them get some idea of what is what. Till we see in the next video, this is Krishnan signing off. Thank you.